All right. Good morning, everyone. Assalamualaikum warahmatullahi wabarakatuh. My name is Aristius Kadarmawan. I am a researcher here at the Center for Sustainable Ocean Policy at the Faculty of Law, University of Indonesia. It gives me a great pleasure to welcome you to this webinar series on comparative law enforcement model at sea, lessons learned from Indonesia, Australia, and Malaysia. To give a little bit background about this webinar, this is part of our research project funded by the Indonesian Ministry of Higher Education, aims to provide a give policy recommendations on maritime security governance in Indonesia. And one of our methodology is to do comparative analysis between Indonesia, Malaysia, and Australia. Today, to discuss the topic, we have a very distinguished speakers about the issues. The first one is Rear Admiral Huta Barat, who is the Deputy Operations and Training of the Indonesian Coast Guard, BAKAMLA. He was the Chief of Staff of the Indonesian Navy First Fleet Command. Prior to that, he was the Vice Commander of the Indonesian Naval Staff College, Commander of Sea Battle Groups, and the Indonesian Navy Western Fleet in 2014. Rear Admiral Huta Barat graduated from the Australian Command Staff. He has a diploma in Defense Strategic Studies from the University of New South Wales in Australia, and he has a master's degrees in Maritime Studies from the University of Wollongong in Australia in 2017. So welcome, Pak Huta Barat. And our second speaker is Dr. Ari Afriansyah, who is a senior lecturer at the Faculty of Law, University of Indonesia. Besides teaching duties, currently he is also a chairman of the Center for International Law Studies and Center for Sustainable Oceans Policy here at the faculty. He is the editor-in-chief of the Indonesian Journal of International Law and also the editor-in-chief of the Indonesian Yearbook of International Law. He's also the executive council member of the Asian Society of International Law. He obtained bachelor degrees from the Faculty of Law, University of Indonesia, master's degree from the University of Sydney School of Law, and his doctoral degree from the University of Otago in New Zealand. And our third speaker is Professor David Letts. Professor David Letts is the professor and director of the Military Law Program and the director of the Center for Military and Security Law at the Australian National University College of Law. He arrived at ANU in late 2012 after a career of more than 3 decades in the Royal Australian Navy. Professor David's research interests center upon the application of legal regimes to military operations, and he has written on topics including military justice, law of the sea, law of naval warfare, international humanitarian law, and legal issues which arise on peacekeeping operations. He has Master of Law degrees from the Australian National University. And our third speaker here is Professor Salawati Matbasir, who is an associate professor at the Faculty of Law, University Kebangsaan Malaysia. She obtains a bachelor degree, master's, and doctorate degrees from the Universitas Kebangsaan Malaysia. Prior to joining the UKM, Dr. Salawati held several professional positions, including practicing advocate, solicitor, legal advisor, and in international trade and development officer. Dr. Salawati interests including development law, international law and strategic studies, the law of the sea, and integrations and regionalisms. In particular, she writes about law of the sea, financing for development, sustainable development, and nuclear security. So I think we have a very distinguished panels for these sessions. So to begin with, we will start to hear from Rear Admiral Huta Barat about the current Indonesian practice in the maritime security governance. To Pak Huta Barat, time is yours, Pak. So the time is maximum 20 to 25 minutes. The floor is yours, Pak.
Oke, terima kasih Pak Aristio. I would like to share my screen first. Hold on. Bisa lihat, Pak?
Sudah Pak, terlihat.
Salahnya sekarang saya nggak bisa lihat.
Oh ini malah tidak terlihat Pak.
Sebentar, jadi kok malah nutup. Saya ketutupan sama screen ini. How can I do? Hold on. Oke. Oke, baik. Terima kasih. First of all, I would like to apologize because the head of BAKAMLA, Indonesian Coast Guard, cannot attend this webinar because something that he have to do now. And then I would show this presentation on behalf of him that according to the committee, I put the title is a current Indonesia law enforcement at sea practice atau studi kasus pelanggaran wilayah China Coast Guard 525204. At the end of the presentation, I would show the recent cases, the recent case between our Coast Guard with China Coast Guard. First, as we already know, this is the background that if I may just conclude this, that no countries can do to solve the problem in the maritime issue, only a single country. So we have to be a multi-state, and then internally in the countries we have so many agencies internally in the countries. So for Indonesian case, we have some issue about the scope of the authority, and then another issue is about the first whether unity of command versus unity of effort. But after all, what we need is what we have to achieve is for a good order at sea. So this is the maritime threat or maritime issue about the encroachment at sea, armed sea robbery, accident at sea, transnational crime, illegal fishing, pollution at sea, terrorism at sea. Even it's become an issue for terrorism at sea, in particular in Indonesia area, because many people doesn't agree with the term of terrorism at sea in Indonesia case. And then the old issue is about invasion, although it's not very common anymore, but I put this as a maritime issue. And this is the maritime governance in Indonesia. There are 24 national laws in Indonesia, and among of them, there are 6 agencies who have a patrol boat, who have a fleet. So you can imagine that there's so many agencies in Indonesia water, not only under the 20, or not only agencies itself, 6 agencies, but also 24 national law. And then this is, if we may put the area of authority, here's the BAKAMLA. BAKAMLA is the Indonesian Coast Guard. So he has a duty from the sovereignty, I mean the territorial sea, till the economic exclusive zone to the high seas, and the navy as well. While the fisheries only, as shown in the slide here, custom, police, and port guard, what we call it KPLP. And this is the shift of maritime threat that we already knew, I believe, from the traditional maritime threat, which is military as a main component, to the non-traditional maritime threat, which is the civilian maritime law enforcement agency as the main component. I believe this has become the global issue, so we also have this issue in national issue as well. And I show you the maritime security fatal helix concept. This what we have to be concerned about: regulation, law enforcement, and then economic agents. This is what we have to consider while we make a decision policy in a government for the government people. And then next, BAKAMLA at a glance. I show you that actually from 1972 we already have what we call BAKAMLA, but under the Navy, and then in 2005 we have BAKAMLA, which is under the government, but under the coordinated minister. Then, since 2014, actually, we already have a Indonesian Coast Guard, but still not, if I may say, not supported very well, or not running well. The movement from 24 until 2020, that our recent head of BAKAMLA, that again the president um, makes some emphasis that the enhanced role function of BAKAMLA to play its role as an Indonesian Coast Guard, although it's actually already started from 2014. This is the task, function, and authority of Indonesian Coast Guard. And this is, like I said to you, that actually since the very beginning, when the President Jokowi became a president in 2014, he already makes some emphasis to make only one agency, which is BAKAMLA, to do its role. But we still now we still going in process. Hopefully, day by day it will be better and better. And this is the president policy direction recently in 2020 that he said in the future only BAKAMLA will be given an authority at the sea. And then he also give the direction that the matters of battle unit from six stakeholders or six agencies that I mentioned before, as soon as possible as we carry out. So what his order is that on the sea it will be only Navy and Coast Guard only. And this is the vision and mission that we have at the moment. We would like to encourage the ability to become GMF and then maintain sovereignty and independency, protect the use and sustainability of natural resources, and then maintain security and safety in jurisdiction water. I'll show you the best practice that what we already done between between BAKAMLA and TNI with the Indonesian Navy in 16 December 2019, where the China Coast Guard entering our EEZ. Then we do the cooperation. I mean, we have a capability to monitor it, and then we also do the cooperation with the Navy at that time. So we side by side solve the problem. And then this is the BAKAMLA practice between BAKAMLA and then the Lingkungan Hidup Environment Agency and then Custom. And this is between BAKAMLA, ABF, and then NMEA, and Indonesian Coast Guard and MMEA side by side, hand in hand, solve some maritime issue as well as with the ABF. And then actually we have many things like this. I just show some example, and then I go to the hot issues, which is just a couple days ago in 11 September that we found the China Coast Guard came into our EEZ, and then our ship asked to the Coast Guard ship, and then we tell them what their intention, and then he said that the China Coast Guard said that we are doing patrolling here, and then we said this is Indonesian EEZ, and then he said that this is in China territory water. He said the, the crew said like that, and then we asked them to tell them that according we are not recognized about 9 days line, and we believe or we know about the innocent patient and so on, but in this case, if you say this is your territory of water, and then you do the patrol, it means we are not recognize what you do, and then we hope that you leave this area. Then they didn't do at the time, in the very beginning they didn't do, and then but at last after about 2 or 3 days, then they leave the area. And then at that time we also asked to the Navy came to the area as well, so both uh, Indonesian Coast Guard and Indonesian Navy in the area, and then the China Coast Guard then leave the area. And then if I may say, it's actually quite often they do the thing like this, and then quite often as well we ask them to leave the area, and then this is the most recent one. And then so if I may share the China ways of conduct based on our experience, that we find that first the way is maintaining conflict escalation by prioritizing civilian ship and Coast Guard back up its naval forces, and then implementing what we call salami strategy, as seen by its conduct in South China Sea since early 1970, and prefer to use bilateral framework to solve any dispute in South China Sea, because we also have a similar issue between Indonesia, China, and Malaysia in some cases. So it seemed that, or we found that they prefer to do the bilateral framework. And then the perspective of South China Sea, this is what we believe, what my crew believe, uh, what we based in our policy while we do the operation, that the historical claim of South China Sea by China is unilateral. It doesn't meet for UNCLOS, and then this argument has been discussed and countered through the 26 SCS tribunal verdict. And then Indonesia also rejected the term 11 waters of China because it was unknown in UNCLOS 1982. The Indonesian has consistently rejected China's harsh action in South China Sea, and based on 1982 UNCLOS, Indonesia doesn't have overlapping claim with China. So it is not relevant to any dialogue about maritime boundary delimitation. That's what my crew as well explained to the crew of the China Coast Guard ship while we uh, often meet in the area. And then so that's all for my presentation. I believe we can do some discussion rather than a slide like this. Thank you very much.
Thank you very much, Pak Huta Barat, for the very interesting presentations about the historical background and also the institutional framework of maritime security in Indonesia, and also for bringing China to the discourse, which I think would be very much interesting in the Q&A sessions. Before we move on to the second speakers, I would like to suggest all the participants who have a questions, you may put the questions in the chat box. It could be both in Bahasa Indonesia or in English, which I can try to translate it to our foreign speakers. So our next speakers would be Professor David Letts. The time is your professors, maximum 25 minutes.
Okay, thank you very much, and I'll just try and share as well. Is that, have I done this correctly?
Yes.
Perfect. Thank you so much.
Yes,
Thank you, Admiral, for that presentation. It was very, very informative. And thank you also to CSOP, Aristio, Ari, for inviting me here, but also from my perspective for permitting me to be involved in something that's in English, because my Bahasa is extremely poor. So I really do appreciate that as well. I should also, just for completeness, indicate that not only do I have my role here at the Australian National University, but I also have a part-time position at ANCORS at the University of Wollongong. So I should acknowledge that as well. The approach that I wanted to take today was to talk about some of the key agencies that are involved for Australia, some of the legal issues that Australia has confronted, and a couple of case studies that really just show how this has, how it's played out. And a number of them have involved either cooperation with or involvement with Indonesian authorities as well. So I'll look at border protection, which is an issue that affects both of us, a little bit about fisheries enforcement, criminal activity as well as, and then finally some of our regional engagement activities. Before we started this, Ari was suggesting to me that perhaps Australia is a little bit further advanced than Indonesia, and certainly the Admiral's slides indicated you had so many agencies involved in law enforcement at sea. Well, Australia is not that far advanced, I'd suggest. So we do have a number of agencies that are involved. The Defence Department, particularly the Navy, through the provision of patrol vessels, but also the Air Force with aircraft making patrols as well. And then in terms of the way that the Defence Department is organised, operations at sea come under the authority of the Commander Joint Operations, as opposed to the Navy itself or the Air Force itself. The assets are assigned to CJOPs. We also, though, reasonably new body is the Department of Home Affairs. And within the Department of Home Affairs sits the Australian Border Force. And then within Australian Border Force sits Maritime Border Command. So I'll show you a little bit how that works out as well. But then we have our state and territory police forces who have capacity and jurisdiction out to 200 nautical miles. Sorry, I should say whether they have capacity to patrol that far out to 200 nautical miles is perhaps a question that you could ask. And one key agency that we have also is the Australian Fisheries Management Agency, which clearly has a role out to the outer edge of the exclusive economic zone. So it's not quite a one streamlined activity or organisation with control over everything. In terms of the assets that are involved, here's some pictures here of the key Australian Border Force assets. The large vessel Ocean Shield, as you can see there, the much smaller vessel here, which is it's got a strange name that I can't remember. Thyack, the Australian Border Force vessel Thyack, and then the Cape class patrol vessels that the Border Force has as well. In terms of the Navy, the primary work is done by two Cape class patrol vessels that are being operated by the Navy, as well as the Armidale class patrol vessels as well. And you see that the descriptions that appear on the website, which is where this text has come from Navy's website, indicate that these vessels worked hand in hand with a range of government agencies as well as the Border Force itself. legal framework that that we're dealing with here is, first of all, as has been already indicated by the Admiral, the 1982 Law of the Sea Convention. And it's important to note the difference, as was highlighted in the Admiral's presentation, of sovereignty and sovereign rights, a clear difference that exists in terms of the operations that can take place. But don't also forget about fisheries regulation in various areas. So I'm talking about international fisheries regulation that exists. And this is important for both Indonesia and Malaysia and Australia in terms of IUU fishing, dealing with that activity, but also conservation of fish stocks and fish resources. In terms of Australia's domestic law, we also had, up until the entry into force of the Maritime Powers Act back in 2014, that act came into force, we had a whole range of different legislation that was applicable in the maritime environment. Importantly for Australia, the Maritime Powers Act standardised the maritime enforcement powers that exist under all of these different, so as it says there, 19 sets of enforcement powers. And in Australia's case, in say the Navy's case, it could mean that if you had an authorisation to go on board a vessel, a foreign flag vessel, in say the EEZ for one particular purpose, say a fisheries purpose, and you went on board the vessel and found a whole lot of people on board the vessel, your authorisation to be on board would not extend to, say, Customs or Immigration Act. You would have to get a different authorisation. And so one of the things that the Maritime Powers Act did was to remove this really crazy operation. Say, look, it's hard enough as it is. For those of us who've done boardings at sea, it's hard enough to get on board vessels sometimes, let alone to have to then go back off the vessel because you had the wrong authorisation. So the Maritime Powers Act for Australia has been a crucial piece of legislation, not just for Navy, but for any officers who are authorised under the enforcement powers of that Act. They could be Border Force officers, they could be fisheries officers, they could be customs officers, immigration. So it doesn't matter. It's a very, very important piece of legislation. But then we have other bits of legislation that still exist and have relevance. So Crimes Act, our Commonwealth Crimes Act. So the crime of piracy, which of course exists outside of the territorial sea. That's defined in our Commonwealth Crimes Act. We also have Commonwealth Crimes at Sea Act that sets up other criminal activity and jurisdiction for the states and territories as well. That's all set up in our Crimes at Sea Act. And then we have a range of different fisheries legislation that is still applicable, as well as Migration Act, Customs Act, and so on, which are relevant in terms of offences under those bits of legislation. So that's important to know as background. The legal framework, it's reasonably complex. I should also then, just as a preliminary point, mention that Australia has a very large search, rescue and response region. So you can see that it extends, if you can see where my arrow is pointing, it extends down all of this way right down into the Southern Ocean. So that has implications for us in terms of our search and rescue region. It's estimated that this region here covers about one-tenth of the Earth's surface. And some assets, particularly getting out here and down here, some of the assets that we need are much bigger than those pictures that I previously showed you. And in fact, when we've been involved in operations down here in the Herd and Island and McDonald Island area and down south in Macquarie Island, if you send a frigate down this area, down this region, you also have to send a petrol tanker out with it so that it can refuel to get back to port here. So it's vast different distances that we're talking about in this area. So the first case study that I want to talk about a little bit about is the boat arrivals, and this is one that Australia's worked very closely with Indonesia. We've had people arriving in Australia by boat. some would say since the 1700s, where European settlers came into Australia. But in terms of recent times, we had large influxes of people from about the mid-1970s. And many of you would be aware that Australian government policy in relation to people seeking to arrive in Australia has hardened over a number of years. And we have a number of different border protection operations that have been in place. But there you can see the numbers, and this period in particular on the slide from 2010 through till about 2014 was a period where Australian government was getting quite concerned about the numbers of people that were arriving in Australia. There was also a significant number of deaths that were occurring at sea as well amongst these arrivals. And again, it was that period 2010 to 2014 that was causing the government to take very firm steps in relation to people seeking to arrive in Australia by boat. Many of you might be aware of the Tampa incident that took place in 2001. That incident was one where Australia really did change its attitude towards people arriving in Australia. And this, again, the force that was used to deal with the Tampa, which I must emphasise, this was an operation that involved both Australia and Indonesia. And the Tampa picked up people who had reported they were in distress, but they actually picked them up in Indonesia's search and rescue zone. The Tampa was on its way up to Singapore and beyond, and it sought to drop these people off in Indonesia. The people that it rescued, the rescuees as they were described, got agitated at that thought, and so the vessel headed towards Christmas Island, and then that's when the government decided that these people would not come and be landed on Christmas Island, and instead the Australian Navy, you can see the areas involved here and the distances involved. The Australian Navy, here's a couple of photos of the people. You can see a very crowded boat. You can see the type of vessel. Here the people are on the deck up in the areas where it's clearly unsanitary for them. And eventually the Australian Navy a vessel of the Navy was tasked to pick up. It was HMAS Manura that was tasked to pick up these people and take them around the other side of Australia. So sail above Darwin through the Torres Strait, and they were offloaded in Nauru through some arrangements that were very hastily entered into by the Australian government. So that really commenced the start of a much harder attitude that successive Australian governments of either side of the political fence have had towards people seeking to enter Australia illegally by boat. And that of course has caused some issues in the region as that policy of the government has unfolded. It led to the creation of Operation Sovereign Borders by the coalition government when it came into power in late 2013. And Operation Sovereign Borders is described as a border security operation supported and military-led that is assisted by a wide range of other agencies. Now, it has a joint task force that's established to ensure that this whole of government effort is adequately addressed. And there's 3 operational task groups that you can see there, one led by the Australian Federal Police, the Disruption and Deterrence Task Group. That one is, it has a lot of engagement with your country, Indonesia in particular. Then there's one that the Interception, Detection and Transfer Group that's led by Maritime Border Command. And then there's one that looks at resettlement and returnings, and that's led by the Department of Home Affairs now and the Australian Border Force. So 3 distinct elements from a border protection perspective. And here's a chart that shows how these agencies sit within the Department of Home Affairs. So you can see the JATF on Operation Sovereign Borders is headed by, in fact, an Army officer on this occasion. Prior to him, it was an Air Force officer. It's actually never been headed by a Navy officer at all. The Navy 2-star comes in down here in Maritime Border Command there. But you can see, and they're the agencies that I talked about in relation to those activities. But if you look right down the bottom, you can see that there's a lot of other government agencies, 15 to 20 other government agencies that are working to support Operation Sovereign Borders. So it's not simply a one agency that has overall control of all the supporting agencies that are needed. So that's important to note as well. The government has put out a comprehensive communications process, I suppose, of saying that if you try to get to Australia by boat, you're not going to land in Australia. And that's been supplemented by the arrangements that have been made with Papua New Guinea and Nauru in particular to house people who are trying to get to Australia there before they can be resettled. So that's been the way that Australia, just very briefly, the way that Australia has sought to deal with border protection in relation to the movement of people in recent times. Finally, on this, you would be very familiar, I think, with the orange lifeboats that ended up on your shores in Indonesia as a result of Australian Border Force and Navy vessels towing people back to your borders. And unfortunately for Australia, very public, well, it was very public that Australia, in fact, went further than they were entitled to do so into your waters in ensuring that these lifeboats reached Indonesian waters. So, so my point of saying this is not to embarrass my country, but to say that these incidents have happened. They're a matter of historic record, and it can be very difficult dealing with some of these operations and getting it correct, even if you think you've planned it all properly. Sorry, I should just indicate here. So these are some of the legal issues that have arisen from these turnbacks that have taken place, including allegations that too much force have been used, and they've been strongly denied those allegations. Just talked about the towing. Allegations that not just have people been transferred off vessels, but there have been extra people that have come from somewhere there. And then, as I said, this public apology that took place as well. Finally, on this point, I do want to make the point that there have been legal challenges to the approach that has been adopted by Australia in our courts here in Australia, but not only in Australia, and this case here of Belden versus Pato and others. This was a Papua New Guinea Supreme Court decision which ruled that the arrangement that Australia had entered into with Papua New Guinea was unconstitutional from a Papua New Guinea point of view. So that's been very, very important to note as well. So, so that's what we've done in relation to that. I now want to turn very briefly to fisheries enforcement. And as I mentioned, IUU fishing is a major issue for us, as it is for Indonesia. We have engaged in information sharing with those countries listed there on the slide. Out in the high seas, we have used vessel monitoring systems as well as boarding and inspection, high seas boarding and inspection. We've cooperated with Papua New Guinea in the Torres Strait to deal with incursions that have occurred there. In the Southern Ocean, we have a treaty with France that provides for both authorities from both states, both France and Australia, to monitor and surveil those areas. And we've worked in the Pacific Ocean, so right around Australia. We've worked with the Foreign Fisheries Agency as well as France, New Zealand, and the United States as well. We have quite famously, so this is back in 2001, we've quite famously engaged in some very, very long hot pursuits that took place down in the Heard McDonald Island area. We had a fisheries management vessel at the time, not a Navy vessel or Border Force vessel, that was patrolling this area. It found the vessel, South Tommy was this vessel, fishing in that area. Initially, that vessel was told to go back to Fremantle. It chose not to do so, turned and headed towards the southern Atlantic Ocean. This vessel was chased by the Southern Supporter, the fisheries management vessel. And while that was taking place, we flew some military people across to South Africa. We got assistance from South African authorities. We had a South African National Defence vessel come out from Cape Town, and the vessel was boarded about, from memory, it was about 300 nautical miles south of Cape Town. We had on board that vessel not only people to apprehend the crew, but also we had people who were capable of sailing it back to Fremantle, and that's precisely what happened. So the operation started properly on the 29th of March. It ended on the 5th of May with the Navy, they were Navy people, steaming party, bringing the vessel into Fremantle. So that's an example of the length that Australia has gone to stop IUU fishing in the Southern Ocean. Some of the legal issues that arose from it, I've just described what took place, but some of the legal issues include things like the hot pursuit itself, the cooperation of the South Africans, and then whether, having apprehended the vessel, whether there was a legal capacity to sail it all the way back across the high seas, where ordinarily there would be high seas freedoms, of course, that exist. Our courts were comfortable in saying that that was legally permissible to take place. And of course, here's the requirements that exist under Article 111 for a hot pursuit. These were all found to have been validly abided by during that pursuit. In terms of criminal law, we've also had instances much closer to our coast, and here's one that involved the Australian Federal Police, the Victorian Police, Coast Watch as it was in those days, and Customs. Coast Watch is the predecessor to the Australian Border Force, or one of the predecessors. And there was an attempt to smuggle 150 kilograms of heroin ashore down here off the coast of Victoria. This vessel was Tuvalu flagged, owned by some North Korean entities, and it attempted to, as I say, to land this heroin here. When it did so, a crew member somehow or other was killed or died, and that crew member was left on the Victorian shores. So from Australia's perspective, that enlivened criminal jurisdiction. The flag state jurisdiction was no longer absolute and complete. And from Australia's perspective, the fact that there was a deceased person from the vessel on the Victorian coastline, along with some drugs, Australia said, well, this enlivens our criminal jurisdiction under Article 27 of the Law of the Sea Convention. And so directions were given to that vessel to head to port for that criminal investigation. It refused to do so. And so that's when this operation was undertaken. It was back in 2003. HMAS Stewart was sent to sea for the purpose of interdicting the vessel. It had with it a couple of helicopters. It had some people on board who were able to get on board by roping down onto the vessel. It was very quickly detained, and that pursuit was effectively carried out. It was escorted to Sydney. The vessel was immediately forfeited, and the crew were prosecuted. As it turned out, the master and crew, the prosecution was overturned on appeal, but nevertheless it took place. Ultimately, the vessel was sunk during bombing practice by the Air Force as well. And then the final point that I wanted to talk about here is just some of the activities that have been taking place in terms of regional engagement. So another key element from Australia's perspective for law enforcement is the engagement that we have with countries such as Indonesia. So we have the comprehensive strategic partnership that was agreed earlier this year, and in that document there are eight separate streams under maritime security cooperation that exist for Australia and Indonesia to undertake, as well as training activities taking place between various naval, border force and military law enforcement forces, as well as the annual maritime security desktop exercise that has been hosted there in Indonesia for many years now between Indonesia and Australia. So that completes what I wanted to say. I'm very happy to take up any comments when we get to the Q&A or questions when we get to Q&A. Thank you very much.
Thank you very much, Professor Letts, for very interesting and enlightening presentations. I think one of the highlights which I underlined here is that Australia have some kind of a Maritime Power Act, which standardized the Maritime Enforcement Agency, which I think it could be very important lesson learned for Indonesia, whether should we have some sort of like a maritime security bill that's specified and standardized, or the law enforcement agency. So thank you very much, Professor. Looking forward to the Q&A sessions. So, and then the third speaker would be Professor Salawati Matbasir from the University Kebangsaan Malaysia, which would share to us the experience of Malaysia in terms of maritime law enforcement. So Professor Salawati, the floor is yours, Professor. 25 minutes.
Okay, I hope that, first of all, thank you very much to University of Indonesia, CSOP, for the third time I'm joining you. Just I want to ask that, is it you going to open my slide, or I have to open by myself? Yeah.
I think someone from us share it for you.
Okay. All right.
There you go.
Yes. Okay. Thank you very much. My topic is about Malaysian law enforcement at sea, legal and institutional systems. All right. For next. All right. For introduction, for Malaysia, maritime security is a manner of life and death, because we are a maritime nation. And one of the key problems that in this respect, that why we have to look at these are very important, because we're enforcing the laws that combat maritime security threats. Malaysia is surrounded by Malacca Strait and also South China Sea. We're having so many security threats actually. So in Malaysia, the Malaysian Maritime Enforcement Agency, or MMEA, has been established as the Malaysian version of the Coast Guard. And it's actually, we start to have this back in 1999 actually, but MME was formally established with the enactment of the Malaysian Maritime Enforcement Agency Act of 2004. In Malaysia, wherever you want to establish any units, any new department, we need to have an act, so that they can have the powers and jurisdiction to do their duties. So since the MMEA became a fully operational agency on 30 November 2005, so it's just about almost 15 years from this year, it has been placed under the Prime Minister's Departments of Malaysia. Why? Because our governments are really, really concerned about what happened at maritime issues around our country and also in ASEAN region. So if we put this agency under Ministry of Defense or other ministry, our government cannot get directly what is the problem. And also for the budgetings, they will be hindered from to get much budget, rather than if a direct under the Prime Minister Department Office. So at any time, the Prime Ministers can get directly report from the Director General. And this is also special because the Director General of MMEA is actually appointed by our Yang di-Pertuan Agong with advice by the Prime Ministers and the Cabinet. So he's not a simple person. He's going to be someone that really got a good background in a maritime and also law and enforcement. Next. So I showed to you that the functions of MMEA, Section 3.2 MMEA Act 2004 says that MMEA is to employ in the Malaysian Maritime Zone. It's clearly in our maritime zone for the maintenance of law and order. the preservation of peace, safety and security, the prevention and detention of crime, the apprehension and prosecution of offenders, and collection of security intelligence. So this is why they are being employed, and this is what is actually they have to do. So we really understand that it will be somehow rather can be having a problem, or maybe a little bit redundant with others agency, but I will explain later. But for Section 2 MMEA Act 2004, we will exercise this MMEA are to be exercised in Malaysian maritime zone, which include the internal water, territorial sea, continental shelf, exclusive economic zone, and the Malaysian fishery waters, and include the airspace of over the zone. Regarding include the airspace over the zone, there is many people's critiques, even from our own scholars, but actually they never practice that. They only practice the internal water, territorial sea, continental shelf, EEZ, and also the Malaysian fishery waters. Next. Okay, we have to know what is the function, because in the legal system and institutional system, we need to know that what is the function. So the Act through Section 6.1 clearly stated that the function of our MMEA is to enforce law and order under any federal law. So they can enforce their power, they can enforce the law and order as long as it goes together with any federal law. And B, to enforce maritime search and rescue. So this is what normally they do. And C, to prevent and suppress the commission of an offense. D, to lend assistance in any criminal matters on a request by the foreign state, as is provided under the Mutual Assistance in Criminal Matters Act 2002. Somehow or other, there is some problem that there is a murder happened in the ships, which is these people they go through Malaysian waters, and there is a criminal happens there, especially murder. So this agency will try to help and lend assistance in this criminal assistance together with the police and the Attorney General's chambers. E is to carry out air and coastal surveillance, this is their practice. Every day they will do this. They carry out air and coastal surveillance, especially at the sensitive area. And this is to ensure that our Malaysia maintain our sovereignty as this maritime area. F, to provide platform and support services to any relevant agency. That definitely MMEA work together with any other agency to ensure the coordination of the information, and also any problems that in maritime can be secured as soon as possible. And also that G, to establish and manage maritime institution for the training of officers of the agency. So we need to have more people in MMEA. We need to have more experienced officers to handle the situations, yeah, in the situation where now I think become very complex. I have to say that there is a challenges that I will explain later that need us to have a very quick and good response officers towards any situations. And last but not least, the H, generally to perform any other duty for ensuring maritime safety and security, or to do all matters incidental thereto. So this is another work by this MMEA. So this is already being stated clearly in their act. This is what they can do for as a functions. Next. Okay, we know that there is what their jurisdiction, but what is the power for them? Yeah, for what is the power for them? So MEA, through exercise of its enforcement powers, it's empowered to investigate any offense which has reason to believe is having committed, or is about to commit it, or has committed. So this is important for their for power for them. So if they got a call, a distress call, they can always go and help, even though that is not yet been committed. So this is where they have to be in the situation where they have to get ready and they have to respond as soon as possible to that. So we need latest fleet, we need a good equipment, a good asset for our officer and the staff at MMEA. And as well as to arrest any person whom he has reason to believe has committed an offense at sea, the Section 72 HMMEA Act 2004 already that give such power of investigation and arrest exercised by the MMEA must of course comply with the legal requirement of the Criminal Procedure Code, meaning despite they have the power to arrest, but they must come together with the reading of Criminal Procedure Code of Malaysia. So they cannot take any action just because they have that power. That's why normally what the practice is, MMEA officer will call a police to inform any incidents, and the police will come. So this is a very crucial for them, because not all the staff is actually have the law background, and not all the officers also have the background, except for the certain about law of the sea or maritime issues. So when it's come to the Criminal Procedure Code, they have to maintain that act together with the power that given by them under Section 7.2. So this is how they normally put together with the police. So this is the issue is to make sure that people understand. But of course, it's happening at the sea. So these people, as a sole agency, need to go there, need to ensure that everything is in order. So then it will pass the case to the police. Next. Okay. Another also that their powers also that MEA is empowered to demand the production of any license, certificate, or any other document for inspections. Okay, for example, very easy that the MEA can assist the fishery departments and the marine department in enforcement of licensing requirement under the Fishery Act 1985 and the Merchant Shipping Ordinance 1952. Okay, it's not only with the foreign shipping boat, but it's also Malaysian shipping boat. So because why? Because Malaysia having a problem with the drug traffickings, human traffickings, and also other things that been trafficked at sea, especially drug trafficking. So the problem is somehow rather that we will always have a routine checking on our fishing boats to see whether they have the license, that requirement under Fishery Act 1985 and also Merchant Shipping Ordinance 1952. So many of actually the foreign fishermen that been caught by this MEA is normally from Vietnam. Of course, the hotspot is around that South China Sea area of Kelantan and Terengganu. So this is where we got the problem, because the maritime area is a maritime zone is very huge, and the boat that using or the ship that using by the fishermen are really up to date, modern one, big, and they have a radar. And then also sometimes satellite to read where they are. So they come to our maritime zone, then take whatever they want, or like they're doing fishing activities. But when they realize that MEA here, they will run away and ensure them their ships is actually just out of our maritime zone. So this is the problem. And it is the one that I think being concerned by the MEA about to be more effective and to be more like to get more information. And I can say that they're doing a good job at this moment. I think not only they have facing this at the South China Sea, they're also facing many problems at Strait of Malacca, Malaysian area, especially with the piracy issues and also the illegal fishing. So I think here the power of them is already adequate and enough. And I think the only thing that they need at this moment from the government is to give more manpower and also a latest asset for them to ensure they can do better exercise and also their work at this area. And moreover, MEA can also exercise the right of hot pursuit in accordance with international law. They have that right, but so far they not to say they not practice it yet, but there is no news about they practicing or not, because somehow rather Malaysia we have also the ordinance about this the Sacred Act, where some operation cannot be told to public. We have OSA, we call it, where not all the operation, not all inside things that done by any agencies, especially the enforcement agency, can be published, can be told to public. So until today, I don't get any information regarding whether they have a hot pursuit or they do it, but there is a right for them under their act to exercise the right of hot pursuit. So if they do it, they are doing the right things because that was their power being given by their own acts. Next. Okay, this is the recent scenario. This is, I love to bring all the audience, the 85 of you, to the recent scenario in my country when it's come to the MMEA. Actually, in the midst of the COVID-19 pandemic now, Malaysian government attention is focused on public order and tightening border control and also our maritime borders. With the huge maritime borders, we actually having many problems at this time, especially refugees. So, the MMEA cannot work by themselves. They need help from others agency. So we know this thing will happen. And you see, as you can see that the Section 7, subsection 3 MMEA Act provide the agency with the clout to use the power which any related maritime organs may exercise under federal law in the Malaysian Maritime Zone. So of course, MMEA cannot handle the biggest scenario, biggest issue or more serious issue. They need another agency to help them. So an example in OPSECAT, which involved the Navy and MAA. So they have the close operation on information sharing, which is demonstrated between the Navy and MMO through RAKAM, which is Friend of Maritime Program. So resulting in the establishment of a standard operating procedure to regulate communication between the Navy and MEA at sea. We have to understand that Navy is to protect the sovereignties of a country. MAA to enforce whatever is supposed to at sea. So if they collapse or they don't have the coordination each other, then we can't solve any problem at our maritime zone. So that's why we have day by day the training with the Navy to ensure that our maritime borders, especially during this COVID, are not being encroached by any people that we don't want. We have a two biggest problem at the moment, despite we are being condemned or being critiqued by international, but as a Malaysian citizen, I have to stress the words that we can't accept any refugees to our soil. I'm sure that many of you heard about the Rohingya refugees. And at this time of COVID, our country is having war with COVID. We are still not get zero cases yet. So we have to ensure that our economics and our people are in a safe place. We do believe that there is no security for health. There is no security at all. So based on that, our government say we can't accept anyone from out of a country. Even some, about 23 countries already documented. Also, we are not allowed them to come. We close the borders at all for them. So what else the refugees? So you can see that the Rohingya refugees love to come through the water, Malaysian water, and come to our soil. So what happened in last April is about 260 people, so refugees, Rohingya refugees, they came from Bangladesh and they want to come to Langkawi, one of the island or northern part of Malaysia. We have to chase them out. We don't have a choice. With 187,000 refugees in Malaysia, we got enough with that. So we support the action by the government because we know what is the best for our country. And me, myself, support that because I think we got more problem rather than now, rather than we have them. So, but before we leave them back, we give them food. We ensure that they will back to the international waters. It sounds like very bad, but we have a right to do that. So this is helped by the Navy and the combination of MMEA. Next. All right, this is the challenges. I think not any agency in Malaysia would not have any challenges. What else in the maritime borders and also the maritime security issue? First of all, what does MMEA have to face is the challenges of geography. If you can see that my country is like, we have Sabah and Sarawak in Borneo area, and we have the Peninsula Malaysia, which our border, land border is only with Thailand. Even Singapore, we have a strait also, Strait of Tebrau, that separated us from Singapore. And we have Indonesia as our neighbor, far away from Philippines and Brunei. So the challenges of geography at the Peninsula Malaysia is because we have from north, which is a Perlis, bring to Johor, and up from Johor to Kelantan. So this is two sides that's really, really important for us. And also the maritime borders facing between Sabah and Sarawak. We not encourage the Brunei borders because Brunei is in the middle. So see how challenges is for MAA. They have to cover the so huge maritime areas. And that's why they need the coordination by any others, especially Navy, to ensure that the security of Malaysia always in a very neutral and a good basis. Because if not, then we will still have a big problem. Because as I said to you, people love to come to Malaysia through sea, whether they are refugees or also for the drug trafficking. And this is the issues that we can't let it go because it's really harm our people. Secondly, the South China Sea dispute. I think the South China Sea dispute is not only Malaysia facing it. As a country that contests South China Sea by China, I think just now also I see that the Admiral also is talking about the same things for Indonesia. I think Vietnam and also Philippines, these three countries, we do have the same problem. Facing China and South China Sea is not as easy as we can see. Of course, you cannot compare apples and orange. But in this situation, this is what happened. Malaysia, as you can see, that we don't like to fight with anyone. We, since our early leaders, we are always want to have and maintain a good relationship with all of our neighbors, especially our ASEAN neighbors. And we believe that if we can prosper, the network can prosper, ASEAN will be more better in future. So this is what our leaders believe. So we are not want to have any problem with anyone, but somehow or other, if they come and encroach our rights in our maritime zone, we have to protect it and we have to tell them that they encroach someone else's area. So how we do that? I think by sending bullet is not the answer. So at this moment, we are still doing at our level best to have the diplomatic. But the tone of diplomatic will be a little bit different according to the scenario and also the situation at South China Sea. So at this moment, that's what we do. We not yet have any shooting or anything with China Coast Guard or China Navy at South China Sea, but we maintain taking care of our maritime borders, maritime zone at South China Sea. And also that third challenges that this MAA facing is Eastern Sabah Sulu Sea region. As you can see that we have a problem with incident back in 2013 where there is terrorists from Philippines come and rebels in the Lahad Datu, which is killing about 18s to 20s of our soldiers and police. This is something that make us it's a work I can say that wake-up call for Malaysia to see that we cannot really just blind our eyes to the Eastern Sabah area, where the Philippines peoples, illegals can come very easy and go back the same day to their areas in Philippines. It's happened since 18th centuries. There are so many Philippines undocumented in Sabah. It's make a more problem for us. So this is how we employ the ESCOM, plus with the police, with the militaries, and also MMEE. And we got a very good cooperation by Philippines government and also Indonesian government to ensure the Eastern Sabah Sulu Sea region in a peace and harmony. And we know that's not easy, but with the help by other neighbor, we did it well until today. And last but not least, traditional and non-traditional trade in Strait of Malacca. I think that Malaysia and Indonesia, we have our own area in Strait of Malacca. We know what happened there. There is always non-traditional trades. There is always piracy, trafficking by the drugs and also any goods, cigarettes and all that is come from this area. And the traditional issue is where somehow rather Malaysian navies and Indonesian navies sometimes they got a problem there, but normally with diplomatic way we always solve it Kuala Lumpur, Jakarta peacefully. So this is where the challenges for MMEA, because they have to enforce at this area. So this is the challenges at this moment for them when they want to enforce their powers and also the jurisdiction to certain things happen in all these 4 areas. Next. Okay, as a conclusion, Malaysia Maritime Zone is safe and secure at this moment. We try our best to ensure that our zone is safe and secured. And enhancement of maritime security, we need local commitments, as I said, and also cooperation for neighboring countries. We can't work on our own, and MMEA cannot work by their own if there is no local commitment for our people to give them any information if we knows about the traffickings or any illegal things happens at sea, and also the information from the neighboring countries. As I said to you that Indonesia as an archipelago state, Malaysia is a maritime state nations, we need to work. You know, we can't be simply saying that, oh, this is your area, you should take care of it, and this is my area, you should take care of it, because then we encourage more crimes to happen in the betweens of the borders. That's why for MMEA, they really want that the cooperation from neighboring countries to curb any situation in any water levels of any or maritime area in Malaysia. And MMA also need that to enhance cooperation, especially in information and intelligence sharing. As I said, that you can't work by your own. Despite if you have the best equipment or asset, or how best is your officers, but if you don't get the information and intelligence sharing your neighbor, that one is not going to be anywhere. That's why how good it is. I still believe the good cooperation between countries or ASEAN countries with Malaysia, that is will work in a very good manner, and it will ensure that ASEAN maritime issues or any problem can be solved immediately. And last but not least, Malaysia is committed to be a player in ensuring a safe and conducive maritime environment in the region. We really need to be like that. And I think that we really are willing to ensure that our region and also our countries, our neighbor are in a good and conducive, so we can have more prosper to brought or to bring together our country. Next. Thank you very much. And I hope that if there are any question, you can ask the moderator, and I'll try my best to answer. Thank you.
Sure. Thank you very much, Professor Salawati, for the very interesting presentations. I think you highlight, I think MMEA have a very strong legal framework and also strong support from the Prime Minister's office. And I'm also glad that you mentioned that the difference between the Coast Guard and the Navy, and also the importance of coordinations and cooperations among ASEAN states, so to speak. Before we move on to the last speakers, I would like to suggest if any participants want to ask questions, you can put your questions either in Bahasa Indonesia or in English in the chat box, or you can also use if you want to give your comments or questions directly, you can just mention it on the chat box and we will let you. So move on to our last speakers, our very own Dr. Ari Afriansyah, that will be talk about the maritime security governance in Indonesia and context. Dr. Ari, the floor is yours, sir.
Thank you, Theo. Is my slide okay?
Sure. It's okay. Perfect.
Thank you very much. Bismillahirrahmanirrahim. Assalamualaikum warahmatullahi wabarakatuh. Ladies and gentlemen, speakers, thank you very much for giving your insights and sharing information. I really enjoyed and it's really enlightening for us here, especially for me personally. Now, because of the time limit, I will try to share my observation. Well, it's not my personal observation, but it's a team observation, because as mentioned by Theo, currently we have this research on how Indonesian governance on law enforcement at sea, and we try to let's say to have this comparative study with a number of states. As of today, we have privilege to hear the information from Australia and also Malaysia. Today, I would like to focus on three things. First, I wish to talk about the complexity of the law enforcement at sea here in Indonesia, and also about the current governance of law enforcement at sea. And lastly, I would like to give some options of the policy to improve the governance of law enforcement at sea. As we know from this picture, our activity, human activity, is so many, and then we can have a long list of activity at sea. This can be ranged from recreational until the industrial activity of the sea. And this would lead to the regulation itself. Yeah, it means that we have so many sectors that will be regulated by the government, and it is not surprising because with so many activities, indeed it will have a consequence to have so many regulation that try to make a good order at sea of any activities that we conducted each and every day. And this is not only involving the government, but also involving the individuals and also the foreign users of the sea. That is why what we are going to regulate it at sea is not only impacting the Indonesian citizens and the Indonesian legal persons, but also the foreign elements as well. And that is why because of this activity and there's so many traffic, yeah, we can expect that everything is not going very well at all time. Yeah, we will have a number of incidents, we will have a number of crimes, we will have a number of legal violations. Yeah. And if I may borrow one of the slides from the Indonesian police, he had noted a number of crimes or legal violations in all over Indonesian provinces. Yeah, I'm sorry, this is some of in Bahasa, but if you can see here, there are a number of common legal violation and also the crimes. Yeah, you can see there mostly on fishing. Yeah, it could be illegal fishing, could be destructive fishing, and could be lead to the IUU fishing as well. And then we can have the legal violation on drugs trafficking. Yeah, and then also the last one is about the terrorism. Yeah, because as you can see from the area of Indonesia, this is so vastly, and we are really separated by the sea, and this is some opportunity for the criminals to use this area for their what do you call it, committed crimes in the area of Indonesia. And if we take a look at the navigation, you can see here in terms of the marine traffic, it is recorded that more than 7,000 vessels per day is passing through or making a navigation within the area of Indonesian waters. You can see there, we can see the pattern of the marine traffic, mostly on the international routes for navigation and also by the archipelagic sea land passage. And not only that, we can also see the main routes coming from the Java Island, Java Sea as well. So with this kind of traffic, we will expect that it's going to be a number of incidents, number of accidents happening. And also, in addition to the potential of crimes, we would like to may have this worry, yeah, with this vast area of Indonesia, and then we need to have a really strong maritime agencies to take care of this area. And if we take a look at the certain sector, just like a fishery sector, we can see there, despite that, we look at fishery sector itself, but other crimes will follow after that. This crimes is found by the Special Task Force of Illegal Fishing that is established under the Minister of Susi. But now we are still waiting about this continuation of this task force. But apart from that, the important things that I would like to take note in here is that the crimes within Indonesian waters is cross-sectoral. Yeah, not only we take a look at one sector, but also for another sector that can be cross path one to another. And when I said previously about regulating these sectors, it came to the consequence when we have a long list of regulation at the level of law, trying to regulate any activities that relates to the at sea. Yeah, and whenever there's a violation, the law themselves trying to try to specify a certain institution that is responsible to take care or to prosecute any violation or any criminals that is violating to such law. So we can see here there are a number of institutions that involved, but if we take a look at here, there are only 7 of the institution that has the vessel for the patrols. We have the Custom and Excise, we have the Navy, we have the Ministry of Fish and Ocean Affairs, we have the Ministry of Transportation, we have the police, water police, and we have the immigration, and lastly, we have the BAKAMLA. So with this kind of so-called colorful maritime agencies at sea, it creates a number of worries and concerns. But the thing is, we have to underline here, with these so many agencies, it does not necessarily that we're going to fight to each other. We just need to find a way to synergize and try to make it all of these elements comes together in terms of taking security of our waters. So if we take a look at the governance in terms of the regulation right now, we do have the latest regulation, a law number 32 in year 2014 about the ocean affairs. In this law, it is clearly stated that the law divided to 2 different functions. Yeah, the first functions is for the defense, and it is for the Navy to responsible. And secondly, for the national law enforcement, it is under the shoulder of BAKAMLA. Yeah, but what kind of responsibility that lays over these laws? Yeah, it is stated that in Article 62, yeah, they have, or BAKAMLA have the number of function, yeah, such as to formulate national policies in terms of security and safety, to carry out security and safety of early warning system, to carry out guarding, supervision, prevention, and prosecution of legal violation in national waters, to synergize and monitor the implementation of water patrols by related agencies, to provide technical operational support to related agencies, to provide search and rescue assistance to the Indonesian national waters and jurisdiction, and to carry out other tasks in the national defense system if it is needed. And in line with this function, the law gave BAKAMLA some authorities similar to the MMEA. First one is to do the hot pursuit. Secondly, to stop, to inspect, to arrest, to carry, and hand over the ship to the relevant authorities for the implementation for further legal proceedings. This is understandable because in this law, BAKAMLA doesn't granted an authority to have a further legal proceeding, or what we call it as penyidikan or investigation. And it is stated as well that the authority referred in paragraph 1 shall be implemented in an integrated manner in a single command and control unit. So in terms of the regulation, it's quite clear, but up until now, we can observe that this idea has not been well implemented. So if we take a look at the law itself, or law on ocean affairs, this law is actually shown its nature of cross-sector, yeah, and it should be the bridge or a harmonizing law of all regulated regulations in the law enforcement at sea. However, it seems that this law does not provide the solution of law enforcement that contain sector crimes. This law did not harmonize the law enforcement efforts and institution with other related laws. However, it may be understood given the current circumstances. And also, in addition to that, there's also confusion to the reference of the Coast Guard agency in Indonesia. Whether some might think that the Coast Guard is BAKAMLA, some might think it's as the KPLP, the Kesatuan Penjaga Laut and Pantai. She is the officers of Sea and Coast Guard. And as I mentioned before, this law does not provide the authority of investigation to the BAKAMLA. And lastly, the important thing is that still, up until now, there's no implementation regulation from the law itself. So it makes, in my opinion, it becomes a hurdle for the BAKAMLA to fulfill its duty under the law on ocean affairs. So, having that condition, I would like to provide some observation in terms of policy option in this manner. Firstly, at the early this year, President Jokowi has made a number of directives in front of the public, saying that from this moment forward, there is only BAKAMLA that has authority at sea. And he then reiterated again in a few days later, there should be a merging process of patrol force from 6 related agencies promptly. So it means that in line with the law on ocean affairs, the directives of the president is actually should be implemented in no time. Yeah. However, there's a thing that we need to really carefully discuss on how we should merging the process of the patrol force. Yeah, is it the institution, is it the authority, or is it other else? Yeah, and having so many discussion and having so many webinars, having so many meetings, I have taken notes on several proposals. Some of them that I put in here. The first proposal is just said to maintain the status quo. Just leave everything as it is right now. Yeah, there's nothing to do because we think that everything is good, in a good order. Everybody is happy. Yeah. The second proposal thinks that okay, everything is still the same, but maybe we could have a better or stronger coordination. Yeah, talking about coordination, we do have experience that previously we have the BAKORKAMLA, the Badan Koordinasi Keamanan Laut. Unfortunately, it seems that this coordination it does not effective. Yeah. The third proposal is the unity of efforts. Yeah, saying that okay, we do have a number of capabilities, we do have a number of capacities of each of the agencies differently, and then why don't we just unite our efforts and then try to make a single central information that we can share to everybody, but everyone is still on their place at the same time. And the fourth one is the unity of command, saying that okay, now we need to have an institution that actually can serve as the leader, yeah, to do or to tell everyone, but to guide and to let's say to regulate on how this institution should be enforced on the Indonesian waters. But it creates another problem: is who is going to be that leader? Yeah. And another proposal, instead of having a centralized leader, why don't we just have a coordinating leader? Yeah. Some said with our own language is the ketua class, yeah, the chairperson of the class. So we do have this institution at sea, and then someone will stand up as we respect each other, then this institution can have this better coordination. Or another proposal saying that we need to have a single agency with a multitask, saying that all of these agencies should be merged into one institution, and this institution which should be really a bigger institution than anybody, and then this institution should have a multiple tasks that is cross-sectoral that I have mentioned before. The question raised is that, is there any institution that can fulfill all of these responsibility with these so many sectors that needs to be taking cover? Yeah. And the last proposal, yeah, in line with the law on ocean affairs, it says that BAKAMLA has the duty to synergize the patrols. Yeah. And then why don't we just encourage and strengthen that function, and at the same time we also can let's say maintain this multi-door legal process, yeah, because it says the authority of BAKAMLA, it can inspect, it can arrest, and then hand over to the relevant institution for further legal proceedings. Yeah. So the last proposal is basically on what is based on the law on ocean affairs. Apart from that, yeah, if we want to have a better and really comprehensive improvement, then we have two options. The first option is to revise the law on ocean affairs, yeah, to revise the handicaps of this law, or we can have the comprehensive law on Indonesian on legal enforcement at sea, or we can have the maritime security law for Indonesia. And last thing that I would like to share is that there are some factors that need to be considered in realizing for the improvement of this governance of law enforcement. The first one, we need to acknowledge and admit that we have a different capabilities, different capacities of each institution that involved in the law enforcement at sea. And it could be a handicap, but it also can be a positive side. Why? Because if we can work together, try to fulfill on each other, it could be a way of improvement. Yeah. And we need to also acknowledge the areas and the crimes that needs to be covered. It's so many and it's so vast. That's why we need to work together rather than trying to find who is better from another. Yeah. And also the president's directives. Yeah. As the leader of this country, we need to respect of his directives with a careful action based on the law. Yeah. And not to mention the threats coming from outside Indonesia. Let's say, as has been mentioned by Pak Huta Barat, about the encroachment of other countries' intrusion to our territory. And we need to have a response equally, yeah, because they send their Coast Guard, and we try to also have face this intrusion by our own Coast Guard. And this, what do you call it? This Indonesian Coast Guard needs to be present on all areas of Indonesian waters. And lastly, we need to have trust for and between of this institution. If we don't have a trust between ourselves, then I think it's going to be really difficult to have a better coverage and law enforcement at sea. I guess that's all my presentation, and we can continue with the question and answer. Thank you very much. Assalamualaikum warahmatullahi wabarakatuh.
Waalaikumsalam warahmatullahi wabarakatuh. Thank you very much, Dr. Arya Fiansyah, for the very interesting presentations, and also for the proposals, which I think are very much interesting for the discussions. I think our discussions go very much interesting because we have a lot of questions here in the chat box, which I will go through one by one. Because I hope that we have enough time for like 40 minutes. But before that, I think I want to give a privilege to our researcher, Muhammad Arif, Mas Arif, to give a comments or questions directly to the speakers. Maybe please put your comments and questions very brief so that we can get more questions throughout the sessions. Mas Arif.
Thank you, Mas Tio. Thank you for all the speakers for the very enlightening presentations. I'm Arif from the University of Indonesia. I'm also part of the research team with Mas Tio and Pak Ari. I have a couple of questions for Professor Salawati. Thank you very much for the presentation. I mean, according to your remarks, the MAEA Act has really given huge responsibilities and power to MMEA. I think it's an act that any maritime law enforcement agency in any country would envy to have. I'm just wondering what have been the challenges, leading up to that act, and can you please elaborate more on, especially on the interactions between the MAEA and the Navy? I mean, Malaysia, like Indonesia, of course, has been a witness of how the boundaries between the traditional security and non-traditional security is really getting blurred, so to say. I mean, in some countries, of course, activities like illegal fishing, which we traditionally considered as a non-traditional concern, have been used by some countries to assert sovereignty.
Mas Arif? I think he's lost connection, Theo. I think he's lost connection.
I think, okay. Sure, okay. Do you get the questions, Professor Salawati?
Yes, I get the question, but two issues.
Okay, maybe. Okay, so please give your answer very brief and sharp so that we can accommodate more questions.
Okay, all right. Regarding the challenges leading up, the interaction between the EMEA and Navy, of course, it's not that easy. Navy is already too long conquer the oceans, and when the EMEA come 15 years ago, so they always like not happy, not say they're not happy, but they always say, hey, hello, we are the first one, okay? So you want to enforce this thing, you should tell us. So actually, that's why we already have this rakam, or this interactions exercise between two, because we want them to understand that we give a rights to MMEA to do this, because they are an enforcement agency. Because you are Navy, you are actually for the sovereignty. So we don't say that you're not important, but we want to give them things. So you can give your I can say your attention more to the very serious issues in oceans around Malaysia, in our territorial water. So this is the issues. So the challenges is not easy. For 15 years, still we have that here and there, meetings and all that. I'm not saying everything is clear, no, because these two agencies, the Navy and MMEA, is not under the same roof. One is under the Prime Minister's office, one under the very big and important ministry, which is Ministry of Defense. Everybody have their own alter ego. Everybody have their own ego to say that this is mine. But what I can say is, lately, I can say many of an exercise we do, like I showed to you in my presentation, and during COVID they do. So we see that they can interact, but they need to get someone that tell them this is a very important for us to do. So this is a very challenges for both, and especially to MMEA, because they are still trying to understand the law of the sea, because not all their members, not all the person that work with MMEA have this kind of background. So we have another hassle to make them understand law of the sea, the jurisdiction, and what is the problem at the South China Sea, at our area with Singapore, and also with Strait of Malacca. That's one. Second, the traditional and non-traditional issues. Very, very important that somehow rather MMEA facing a very, very difficult when they want to understand and to also to curb the problem, especially illegal fishing and also trafficking drugs at sea. This is the two things that lost for Malaysia, because especially if the China fishermen they come, and especially they in the border of Sarawak, Tempat Tinggi Ali. So this is always where they try to protect them, and then this is how the MMA try to enforce, but they will back off, because they know first the situation is they cannot facing the China Coastal Guard, which is a very huge and big, and also because of the aggressiveness. So this is, I said that to you, that the traditional issue is normally the line between the Navy, Malaysia and Indonesia. Once a while we're facing that, the clash of the ship. Once a while, I don't know which one that they want, because Wisma Putra and Kemlu Indonesia are still ongoing negotiation regarding Strait of Malacca to understand which is the real border both, despite we have the international area and in the between. So once a while we have that problem, but as I said earlier, this is always being solved by the diplomatic way. But the non-traditional issues is a piracy issues, because if we try to get them at Malaysian water, if they go to the international water or they go to the Indonesian water, we can't do anything about it. So this is the challenges that facing at this 21st century, day by day, is getting chronic and then serious by the MMEA.
Okay, thank you very much, Professor. So I'm trying to read the questions here in the chat box. So the first question goes to Pak Huta Barat from BAKAMLA. The question is from Bimo Jewagung, master student here at the Faculty of Law, University of Indonesia. I would like to ask BAKAMLA concerning is there any breakthrough in terms of technologies or regulations to back up Indonesia government to prevent China or other countries naval or illegal fishing ships to enter Indonesia territory without permissions, considering that territorial issues is crucial issues to keep our sovereignty. So is there any specific technology or regulations breakthrough for Indonesia to protect our maritime domains? Please, your answer, keep it brief and sharp.
Oke, terima kasih untuk pertanyaannya dari Bismo. I will answer in bahasa Indonesia ya.
Sure, Pak, please.
Apakah ada permasalahan breakthrough of technology ya? Saat ini sebenarnya kita sudah lakukan itu sudah ada. Kita mempunyai sistem di puskodal kita ini. Saya cukup bangga melihat puskodal kita ini, selain dia memantau, lalu dia menganalisis, kita bagi mulai dari collecting data, displaying, setelah di-display, kita correlating semua data, lalu kita analyzing, lalu baru kita disseminating. Dalam disseminating ini baru kita akan share kepada seluruh agensi di Indonesia. Makanya apa yang kita lakukan ini bukan hanya semata-mata tanda kutip kita nikmati, tapi juga dinikmati tanda kutip oleh agensi lain. Saya bisa menunjukkan banyak sekali slide bukti, tadi hanya saya kasih 4 atau 3 tadi. Itu yang bisa kita lakukan diantaranya. Jelas kita juga punya keterbatasan dengan BAKAMLA yang baru 2014 berdiri. Jelas kalau soal aset kita jelas kurang ya dibanding Angkatan Laut. Tadi juga Profesor Madya ya juga menyampaikan bahwa Navy udah jauh lebih dulu gitu ya. Makanya saya selalu bilang Navy itu di depan kita dan jalannya lebih cepat. Gitu loh. Kita memang masih di belakang gitu. Yang terjadi adalah kita pada saat ini lebih ke teknologi tadi, share dengan mereka, kita mengkolekti data seterusnya tadi. Lalu apabila terjadi seperti kasus kemarin itu ya, Coast Guard Tiongkok, yang China Coast Guard yang seperti bahasa Indonesianya ngeyel lah gitu ya. Yang bisa kita lakukan ya kita hanya bisa melakukan ya kita pantau tetap ada di situ, keberadaan kita yang sangat diperlukan juga ada di situ, dan jelas kita akan berkoordinasi dengan Kemlu. Saya rasa untuk antara negara, government to government ya, diplomatik, protes diplomatik itu udah cukup berat menurut saya ya, karena kita tidak bisa hanya karena itu terus kita berperang, jelas kita tidak mungkin melakukan itu. Yang perlu saya garis bawahi adalah bahwa keberadaan kita itu yang sangat diperlukan. Kami pernah melakukan inisiasi berupa keberadaan kapal-kapal ikan kita sebagai contoh di Natuna. Tapi kita harus menyadari bahwa kita banyak juga permasalahan internal, baik di perikanan dan baik di nelayan kita itu sendiri. Jadi tidak bisa selesai atau menyalahkan atau poin bahwa ini tanggung jawabnya KKP misalnya. Itu tidak bisa begitu, tidak semudah itu. Karena masyarakat kita sendiri juga kecenderungannya berlayar atau nelayan kita sendiri kalau disuruh bernelayan menangkap ikan sampai 6 bulan, 1 tahun itu mungkin dari 1 juta orang hanya 1 yang mau. Tapi kalau di negara lain dari 1 juta orang mungkin ada 500.000 yang mau. Jadi hampir setengahnya mau. Jadi kita kecenderungannya berlayarnya hanya mau sebentar. Nah, sehingga ini adalah permasalahan yang harus dipecahkan bersama. Tapi yang terpenting adalah keberadaan kita, menurut saya, pendapat saya, keberadaan kita baik nelayan kita maupun penegak hukum kita, keberadaannya di laut itu baik di territorial water maupun EEZ, di sovereignty maupun sovereign right itu sangat dibutuhkan. Jelas laut tidak bisa dikotak-kotakan. Yang terpenting adalah bagaimana kita menempatkan kekuatan kita pada waktu yang tepat, di tempat yang tepat. Nah, itulah makanya kita perlu teknologi tadi. Dengan teknologi itu kita share lalu kita sama-sama. Persis kasusnya dengan beberapa hari yang lalu dengan kapal Coast Guard itu. Kita tidak nunggu di sana berhari-hari. Setelah dia pergi ya kita kembali lagi kita pantau pakai teknologi. Mudah-mudahan itu sudah bisa menjawab dari semua. Terima kasih.
Terima kasih Pak. Thank you very much for the very short answer. So the next question, I believe this goes to Professor David Letts. Sir, how Australia handling the conflict against other countries' interventions related to the ships that came to the country, to those countries that have been arrested by Australia? What are the challenges for Australia to enforce the law at sea towards other countries' interventions or refusals, and how Australia overcome it? I hope the question is clear, Professor.
I think I understand what the question is getting at, and in fact, some countries have taken issue with the apprehensions that Australia has done of foreign fishing vessels, in particular, in our EEZ, and there have been a number of cases that have gone to the International Tribunal for the Law of the Sea. The Volga, for example, that case was all about an apprehension that took place. So it's a combination of both Australian domestic law, which gives us that power, but also international law, so the powers that set out under the 1982 Convention in particular to enforce our sovereign rights in the EEZ. The closer in you get, if you're talking about the contiguous zone or the territorial sea, that's the rights become much stronger because you've got sovereignty, of course, in your territorial sea. But even the example that I gave of the Tampa, which was a Norwegian flag vessel, Norway was not happy with what Australia was doing in relation to dealing with that vessel. But Australia said, well, we have rights that we're able to protect in our contiguous zone and EEZ, in territorial sea, and we're going to do that. So, so if I understand the question correctly, that's the approach that Australia takes. We say we're authorised to take this action under both international law and domestic enabling legislation, and we're going to do so.
Thank you, Professor. Before I move back to the individual questions, I think I have a question for all the speakers from Bapak Adrianus Ramon from the Faculty of Law, Universitas Katolik Parahyangan, Bandung. May I have the opinions from all speakers whether the type of provisional arrangement like the Common Guidelines MOU between the Indonesia and Malaysia may be effective enough to prevent any potential clash between law enforcement agencies operating within a certain maritime area with overlapping claims? So maybe the effectiveness of MOU between states to prevent any escalations between maritime law enforcement agencies. So the questions go through all the speakers. Maybe we can start with Pak Ari Alfiansyah.
Okay, thank you, Theo. I just have a short answer. Yes, it should have an impact or effect. However, we should have this MOU with those countries who have the same legal basis for the maritime claims. For those countries who are not basing their claim under international law, we should not make any MOUs. And if we take a look at the statistic, I guess the clash between Indonesia and Malaysia is decreasing when we have this MOU. I guess that's my answer. Thank you.
Thank you, Dr. Ari. Maybe Professor Salawati.
Okay, I agree with Dr. Ari because I think that, as I said to you before, our Wisma Putra and Kemlu is working very hard to ensure that any disagreement or anything regarding both countries can be solved, and the numbers of the problems now, I agree with Dr. Ari, is very less now.
Okay, maybe Pak Huta Barat.
Yeah, thank you. My answer is yes. Of course, if you ask to all the people in a country, they will not simply answer the same answer, like I said. But I just give some example with the Malaysia. When I was, in the Navy, we have between Indonesian Navy and TLDM, Malaysia, we have what we call Prevention Incident at Sea, or INGSI, Malindo INGSI. Malindo is Malaysia, Indonesia. Before we have that, whenever a captain meet to the TLDM captain in the, if I may say, dispute area, and then both captain will have their own perception in their mind. But then, since we have Malindo INGSI, at least there is a guideline between us to avoid the incident. That's the most important thing that I found. And then, like Dr. Ari said, that since we have the MOU, it decreases the issue between countries. And I believe it's same to the other countries as well. Thank you very much.
Theo? Theo, can you continue? Theo?
Okay. Thank you, Pak Huta Barat. And then, yes. Yes, I'm here. Is it clear? Is it clear right now?
I think something delay.
Hi.
Yes, I think this delay.
Yeah. Am I back here?
Yes.
Is it clear right now?
Yes, yes.
Okay. Okay, so Professor Letts.
Thanks, Theo. Look, I don't have any specific comment on the MOU that Indonesia has with Malaysia, but just generally that the issue should only arise if there's areas of dispute in terms of jurisdiction, because otherwise, if maritime delimitation has occurred, questions of where and who has jurisdiction just shouldn't arise. It should be one where each state knows where their own jurisdiction rises. So that's probably all I can usefully say.
Okay, thank you, Professor. So I think I will go back to individual questions. From Dr. Gulardi to Professor Salawati, I would like to seek your explanations on Malaysian fisheries waters. As mentioned in the Act, how does it differ from the Malaysian exclusive economic zones, and where are these Malaysian fisheries waters located? I hope the question is clear, Professor.
Okay, I understand what he means by that, because we have our Fisheries Act 1985. We already said where you can have the fishing area. Okay, actually whatever it is in our maritime zone can be fishing area, except the geopark that we put in Act. The geopark is where we protect the mammals and all those fish. You can't fishing, that area cannot be the fishing area. So that's the only thing. in EEZ zone, you are free to do that, but you can free in any Malaysian water except the geopark that being stated and in the act. That's all.
Okay, thank you, Professor. So the next question is Professor David Letts from Hudian Shah Isnursal, the Deputy Director of International Law and Regulations of Indonesian Coast Guard, or BAKAMLA. Could you give further explanations regarding the Maritime Power Act? Does it give the investigations power to agencies in Australia? And does the Maritime Border Command, as the spearhead of the maritime security agencies in Australia, have investigations power, or it's still based on Custom Act? Is it clear, Professor?
Yeah, thank you. Thank you very much for the question. The primary focus of the Maritime Powers Act is to empower maritime officials, who are the people who are going on board the vessels. And implicit, or actually explicit, it's contemplated in the Act that part of what they do when they go on board a vessel is they will seize documents, records, take certain bits of evidence. But in terms of then going the next step, in terms of arranging a prosecution, it's not the job of those officials, unless there might have been an official from one of the agencies, say the Fisheries Management Agency, who would then take that further. But the either the Border Force or the Navy, it's not their job to go investigating further, just to collect that initial piece of evidence that's required. They'll take, say, GPS coordinates of where the vessel was, photos of catch that they've found, if it's a fishing offence, ship's log, those types of things. Maybe some statements from individuals, but beyond that, it's not their purpose to do so. So in that sense, it's also not the role of Maritime Border Command, as far as I understand it. I must say that I don't work for Maritime Border Command and haven't worked within that command. But beyond what I've just talked about, that's not their scope. Their scope is to make sure that the assets are available to those supporting agencies to then go about the business that they will then have to proceed with. So the example you talked about, customs, it would be customs officials who would have the correct knowledge to look at whatever is on board the vessel and to decide, yes, this is something that contravenes the Custom Act, for example.
Okay, thank you, Professor. And the next question is go to Dr. Ari. Considering the complexities from Fauzan Indonesian Institute of Science, considering the complexity of issues as well as regulations within Indonesian waters, do you think that the Perpres 16/2017 about Indonesia's marine policy is sufficient to provide a basis for synergy between the authorities at sea in enforcing law at sea in Indonesia? Dr. Ari.
Yes, thank you for the question. Indeed, in the narrative of this ocean policy, in terms of the maritime security, it is well written. But unfortunately, in terms of the targets that has been set out in the ocean policy, it's only up to 2019, and there is no narrative of or plan whatsoever in terms of how to make this governance between or among the related agencies be solved. Thank you. Unfortunately.
Okay. Thank you, Dr. Ari. So the next question is for Pak Huta Barat, BAKAMLA. Could you please elaborate more on the functions that differentiate BAKAMLA and Navy in terms of law enforcement, especially in the exclusive economic zone?
Oke, baik, terima kasih. Ini pertanyaannya bisa dijawab singkat, tapi agak sulit juga kalau singkat malah jadi salah. Jadi saya agak panjang dikit. Jadi begini, sebenarnya fungsi angkatan laut itu kita mengenal ada fungsi three universal function dari angkatan laut, yaitu diplomasi, military, dan polisional. Sebenarnya fungsi kita tahu sebelum adanya Coast Guard, kita ribut tentang Coast Guard, sebenarnya tanpa ada Coast Guard pun sebenarnya di Indonesia ini tidak masalah. Kita hilangkan saja Coast Guard. Fungsi itu diambil oleh Angkatan Laut. Selesai. Karena memang fungsi polisional itu ada di Angkatan Laut. Dan tadi disampaikan oleh Profesor Salawati bahwa Angkatan Laut itu sudah ada dari zaman dulu, ya. Jadi makanya kalau kita lihat pejabat-pejabat gubernur dan segala macam seragamnya putih. Itu karena zaman dulu itu yang telah melanglang dunia, itu melanglang buana itu adalah angkatan laut yang melakukan itu. Akan tetapi kalau saya boleh menyatakan kurang lebih seperti demokrasi. Demokrasi itu dulu negara semuanya kerajaan. Semuanya kerajaan, semua dipimpin oleh raja. Lalu keluarlah apa yang disebut demokrasi. Ketika ada demokrasi inilah semua negara sudah tidak bisa lagi menolak yang disebut demokrasi. Kalaupun sebuah negara itu ingin punya kerajaan, maka dia ingin ada tetap bentuknya adalah monarki. Setidak-tidaknya dia akan punya perdana menteri yang dipilih secara demokrasi. Maksud saya adalah secara organisasi di sistem pemerintahan tidak bisa menolak yang disebut demokrasi. Begitu juga secara hubungan internasional. Secara hubungan internasional sudah tidak bisa lagi kita menolak adanya Coast Guard. Coast Guard itu adalah suatu keharusan. Nah, untuk itulah sebagaimana tadi saya bilang adanya negara bentuknya monarki tapi ada tetap perdana menteri yang dipilih secara demokrasi, demikian juga kita tetap perlu memerlukan adanya angkatan laut dengan kita juga memiliki Coast Guard. Jadi manakala yang datang itu adalah kapal yang berbentuknya, kita tahu ya strategi gray zone area yang dilakukan oleh suatu negara. Kalau dia melibatkan kapal Coast Guard-nya mereka atau kapal perikanan mereka, ketika yang menghadapi itu adalah kapal Coast Guard yang tanda kutip non-militer, itu akan lebih apple to apple. Karena begitu sebuah kapal perang meletuskan pelurunya, senjatanya kepada kapal tersebut, itu dapat ditanda kutip dinyatakan sebagai bagian pernyataan perang juga. Nah, disinilah posisi sebuah kapal perang, bahayanya sebuah kapal perang bila melakukan tindakan enforcement. Nah, jadi dengan demikian, apa yang kami lakukan saat ini adalah mengacu tadi yang saya sampaikan, bahwa kami menaruh BAKAMLA di depan, menaruh Coast Guard di depan, dan Angkatan Laut di belakang. Jadi Angkatan Laut akan membackup kami. Angkatan Laut tugasnya adalah ya sebagai Angkatan Laut, sebagai pertahanan, dia akan menjaga, melindungi segenap tumpah darah manusia, tentu saja. Apalagi ada petugasnya. Bila terjadi apa-apa, dia akan turun di dalamnya hal ini. Nah, inilah yang kita lakukan. Kalau suatu negara punya strategi dengan menempatkan white hull, blue hull, nah kita juga mempunyai strategi seperti itu. Apa strategi kita? Strategi kita adalah menempatkan Coast Guard, unsur sipil, BAKAMLA di depan, lalu di belakangnya di backup oleh Angkatan Laut. Mungkin semoga itu jawaban saya yang bisa menjawab dari pertanyaan tadi. Terima kasih. Pak, masih unmute Pak, masih mute. Ya.
Oke Pak, sorry. Terima kasih Pak. Thank you very much. I think it's a very important point which on the difference between a Navy and Coast Guard, which I think I want to hear more from Professor Davids and Professor Letts. Is there any geopolitical or political implications of the differences between when the Navy do the law enforcement and when the Coast Guard, let's say MMA or any other institution in Australia, do the law enforcement? Do you think there's a significant geopolitical impact of that? Do you understand the question, Professor?
Yes, but I don't think there is. That's one of the reasons that the Border Force and Maritime Border Command was set up and deliberately set up, and its predecessor, Coast Watch, and Border Protection Command. They was deliberately set up with a Navy 2-star there embedded in the and a joint Navy and Coast Watch or Border Force staff. So deliberately integrated. That was the government's decision to do that way. And so the assets that are available are either Navy assets or the Border Force assets. The enforcement powers are all under that one piece of legislation that I talked about, the Maritime Powers Act. So for those sorts of operations where they're involved, it seems to be a well-oiled machine these days. Further afield, though, if we're going down to the Southern Ocean, the Border Force doesn't have the assets to send down south into the Southern Ocean. So that's where Navy's capabilities are used. And again, there just doesn't seem to be any great disharmony between the two organisations, realising that it's a capability issue. The smaller patrol vessels just can't operate safely in those environments. So it doesn't seem at the moment for that to be an issue between the agencies here in Australia.
Okay, thank you, professors. Professor Salawati, do you have a take on that? Because Malaysia and I think Malaysia recently facing a very tough situation with China, and I think that it might be a relevant question.
Yes, yes. For me, it's beside that, we have to see that for Malaysia there is an issue of geopolitics and also geostrategy involved. Because for me, it's like we have to be very careful. We know that we want to protect our own maritime zone, and we're not going to compromise with any of our sovereignty. But we have to also realize that we're facing a very aggressive superpower where they don't care, and I think that our MME and also Navy facing many bad things with this China Coastal Guard, especially in area of Sarawak. So I think that that's why I said earlier that we have to be very careful. At the same time, we have to protect, and what we do is we have to be in a very, very tough scenario where our diplomats, our ambassadors, and all those researchers work together at this moment. I'm one of those in that group where we have to try our best how to do next level with China. So if you're talking about South China Sea, there's no other enemies, it's only China. Simple. Yeah.
Okay, thank you, Professor. So the next question is from Kevin Sutiadi from Universitas Katolik Parahyangan Bandung. The first question goes to all of the panelists. Is there any particular international regulations that can be used as a guidance for foreign military vessels or from foreign governors' research vessels to harbor at the coastal state harbor? I hope the question is clear. I think we'll start with Pak Huta Barat, maybe, Pak.
Terima kasih. Kita ini kalau kembali ke ini lagi ke aturan ya, aturan hukum internasional lagi, kita mengenal adanya innocent passage diantaranya misalnya. Sebenarnya semua kapal bisa melakukan apapun melakukan innocent passage sebenarnya. Tapi kita juga mengenal adanya kapal pemerintah dengan kapal perang atau warship, ya, di mana ketika dia memasuki teritorial suatu negara, dia harus mengirimkan mendapatkan security clearance dari negara yang dituju. Nah, disinilah dengan kasus yang kemarin itu di Natuna kemarin kita melihat ada China Coast Guard. Kalau kita berasumsi dia hanya lewat, kebetulan dia akan melakukan perjalanan misalnya dari negaranya, mainland mereka menuju suatu negara, misalnya di Eropa lah. Lalu dia akan melewat Selat Malaka dan melewati Natuna, dia melakukan itu, sah-sah saja, jadi akan lewat. Tapi kan dengan pemantauan tadi kita menggunakan teknologi, kita bisa melihat suatu yang disebut, kami namakan anomali pergerakan. Dia berputar-putar di tempat situ. Nah, dari sinilah dengan pantauan anomali ini, lalu kami datang. Kami bertanya sama dia, Anda muter-muter di sini istilahnya gitu, ngapain aja gitu. Dan ini akan menjadi terjawab ketika dia bilang bahwa saya melakukan patroli, kan gitu. Lalu kita tanya, ngapain lu patroli di sini gitu. Dan terjawab lagi lebih jelas lagi, karena menurut dia ini adalah daerah, bahkan dia bilang teritorial mereka gitu. Nah, dari sinilah terjadi percakapan kan, terjadi sudah jelas ini udah bertahap-tahap. Nah, lalu kita usir mereka. Ketika mereka tidak mau, ya istilahnya kita di negara manapun saya yakin sama, tidak ada negara yang ingin berperang ya. Walaupun kita harus siap perang kalau untuk kita melindungi negara ini kan gitu ya, kurang lebih teorinya gitu. Nah, kita lakukan ya, kita tunggu dulu di situ. Ya, kita minta Angkatan Laut juga hadir diantaranya, dan kita mengirim nota diplomatik juga. Duta besar mereka juga dipanggil oleh Menlu kita. Lalu nggak lama kemudian juga dia kembali. Dari sini juga kita bisa melihat bahwa negara tersebut ya menghargai juga keberadaan negara kita gitu. Pasti mereka juga punya pendapat, punya pikiran strategik ya. Tidak serta-merta harus dia ngotot di situ, nah, akhirnya toh dia pergi. Nah, dari sini kita bisa melihat bahwa sebenarnya mereka mungkin kalau saya boleh berasumsi dengan cara pikir mereka, mungkin mereka coba-coba gitu kan, coba-coba dilihat kita ngusir nggak gitu loh. Kalau diusir ya udah dia ngotot dulu. Kalau masih diusir juga ya dia pergi juga. Karena saya yakin jangan lupa bahwa Tiongkok itu meratifikasi UNCLOS. Artinya saya yakin dia juga ngerti kok UNCLOS gitu. Jadi berpikir dengan ini ya. Peace cannot be kept by force, it could only be achieved by understanding. Itu yang saya pegang bahwa kita juga harus mengerti situasinya. Setelah situasi orang di lapangan, pasti juga dia ada tekanan-tekanan dari pimpinannya di atas. Saya rasa kurang lebih seperti itu. Tapi yang pasti, apa yang kita lakukan ini sejauh ini saya bisa bilang bahwa ini adalah strategi yang baik, yang tepat, di mana kita tidak menggunakan senjata, tapi menggunakan lebih ke arah diplomasi dan aturan hukum. Terima kasih.
Thank you, Pak Huta Barat. Maybe Dr. Ari, do you have any take on that?
Yeah, in regards with the foreign vessel or the military vessel from outside Indonesia or outside the coastal country, UNCLOS has made clear that all of the national law of the coastal country is applicable. So any vessel that wish to go to the territory of the coastal state needs to have a permission, yeah, unless they just have an innocent passage. Thank you.
Okay, thank you, Dr. Ari. Professor Salawati.
Well, I think I don't want to talk much. I agree with the Bapa and also Prof. Davids and also Dr. Arif. I think more or less it's all the same. We don't want to go for war, but we have to protect our own sovereignty, and that is would be the number one, no matter what. So I think that is clear in our international law.
Okay, thank you, Professor. Professor Letts.
The only thing I'll add to what's been said is that internal waters, of course, are part of the sovereignty of the coastal state. And if we're talking about harbours and ports, there's no right for these vessels to go into those areas without diplomatic clearance, which is the normal process. That's the process that would be followed. Territorial sea, as Ari's indicated, innocent passage is available in the territorial sea, but anything beyond that is outside of the scope. Thank you.
Thank you, Professor. Okay, so the next questions will go to Professor Salawati. As you explained elaborately about problems faced by the Malaysian governments on law enforcement at sea, could you please give some more updates on the current situations as regards the regional or trilateral cooperation, such as in handling transnational crimes, like tackling the IUU fishings, as well as solving disputes, especially during the COVID-19 situations?
Okay,
I have the questions for Professor.
Okay, what can I say that during this time, this is a very critical time, Malaysia, Indonesia, Thailand, and Singapore, this is three, Indonesia, Malaysia, Singapore, and Thailand. This is the three countries that we work very hard because with Indonesia, we want to curb the piracy, we want to curb the illegal fishing from any other countries. Because for us, it's very important. We have to protect our people, but at the same time, we have to protect resources. And we have a problem with economics, so this is what our resources. We don't want to lose to any foreign fishermen because of this. Second, I think that regarding the human trafficking and also the drug trafficking, we did well with Indonesia and also with Singapore, where we stopped many illegal immigrants from entering our country, and also we stopped them from going out because we don't want COVID to be spread to any other ASEAN country. And also that I think regarding the drugs and also the cigarettes, it's come from the neighbors, like drugs come from from Thailand, and the cigarettes come from Indonesia. So we work or we get information by all those two countries. So this is what we do at this moment. So almost I think every week we will see in the newspaper that our MME and Navy will have the media cover was telling that this is our achievement with the information by our neighboring people, Indonesia and Thailand. I can see that. Yeah.
Okay, thank you, Professor. So the next questions go to Professor Letts. I'm especially interested in the explanations about the law enforcement on illegal fishing, illegal unreported and unregulated fishing in Australia. could you please give more details such as how Australia government manage their fisheries area or zone? And is there any specific law or act that regulates the IUU fishing in Australia?
Thank you for the question. I think the best thing to say here is, look, there's a number of different ways that it happens. The Fisheries Management Act is the domestic legislation. Of course, the Law of the Sea Convention talks about fishing, but there's also a whole bunch of international activity that takes place, for example, through Foreign Fisheries Agency in the Pacific, Niue Treaty on Cooperation in Fisheries Surveillance in the South Pacific, FAO Code, conservation, if you took Antarctic, BAKAMLA. So there are lots of different international and regional bodies. There's also a lot of bilateral arrangements that Australia has entered into, including 1992 Fisheries Cooperation Agreement with Indonesia. And rather than list through all of those here, it's probably, if I refer the question to the Australian Fisheries Management Authority's website, there's details about all of that on the AFMA website, which you can easily find as a starting point to look at all of that. So in short, Compass, it's a combination of international law, multilateral and regional agreements, bilateral agreements, and then supported by Australian domestic law, particularly through the Fisheries Management Act.
Okay, thank you, professors. I think we have a few more time. To Pak Huta Barat, in the event of foreign navy ships or foreign government research vessels that would like to harbor at Indonesian harbor, what will be the technical regulations for those vessels to enter Indonesian water, particularly the concerning permit?
Terima kasih. Tadi sebenarnya sudah dijawab sebagian oleh Profesor Ari ya. Jadi untuk kapal-kapal pemerintah maupun Navy yang mau masuk ke Indonesia seperti yang pertanyaan tadi, mereka akan mengirimkan diplomatic clearance. Jadi mereka akan sebelum berangkat masuk ke Indonesia, mereka akan mengirimkan kapan mereka datang, jenis kapal apa, krunya berapa, namanya siapa saja. Itu detailnya, itu listnya ada, dan begitu kita kapal tersebut diizinkan oleh pemerintah, lalu pemerintah akan menginformasikan, dalam hal ini Mabes TNI akan menginformasikan pada kepada Angkatan Laut dan pada BAKAMLA, sehingga kita akan menginformasikan kepada kapal-kapal yang melakukan patroli, bahkan dalam case Angkatan Laut misalnya, ketika dia masuk untuk kepentingan kegiatan, maka mereka akan disongsong oleh kapal Angkatan Laut kita di perbatasan, sehingga dia akan masuk ke negara kita bersama-sama. Jadi kapal-kapal tersebut tidak mungkin masuk tanpa izin dari pemerintah setempat. Terima kasih.
Okay, thank you, Pak. I think we only have enough time for one more question from Dini Purnamasari, our research member and also student at Fletcher School, to Professor David Letts. Thank you for sharing us about how Maritime Powers Act 2013 consolidated previous 19 sets of enforcement powers into Act 1. How was the political process in bringing to the force the Maritime Powers Act 2013, and what advice could you give to Indonesia if our government's looking into the options?
Thank you.
Very interesting question.
Thank you for the question, and the reason I'm smiling and laughing a bit is because you've really, I think, understood that this was not easy. From Navy's perspective, initially, they were really the main assets that we used, and trying to get a simplified regime in place was something that Navy wanted for a long time. It took a lot of coordination. It took a lot of talk between the various agencies, and if you just look at that slide that I had with how the border force arrangements are set out, you can see 15 to 20 different agencies, all with their own views about how these powers should be enforced and whether it should be under one piece of legislation or separately. So it took a lot. You're quite right. It took a lot of work to get all of that, a lot of interaction between agencies. What would I say to Indonesia if your government is looking at doing that? Be ready for a long journey to get yourself to where you want to go. Have somebody who is championing the journey itself and making sure that they're putting their energies into getting this outcome, because that's what it will take. It just simply is a lot of coordination work, and it will take time. Thank you.
Thank you very much, Professor Letts, for the insights and suggestions. I think that will be the last questions for our session today. And please join me to give a big round of applause for our remarkable 4 speakers for their insights, and also for all the participants who have active participants for the question and answers. I think we do learn a lot from these sessions, and I think there will be a lot of insights and new knowledge that could be adapted and accommodated for Indonesia, the future of Indonesia maritime law enforcement governance. On behalf of the Center for Sustainable Oceans Policy, once again, I would like to thank you to all speakers and participants. And this marks the end of our webinar today. And we will please keep an eye on our next webinar series. Thank you very much once again, professors.
Terima kasih Pak Tobarat. David, thank you very much. Prof. Salawati, thank you very much.
Thank you,
Thank you, Professor. Thank you all.
Thank you semua. Really enjoyed.
Thank you from me too. Terima kasih.
Thank you,
Thank you, David.
Thank you, Professor.